Mr. Veal, your attorney had filed a motion for intervention in lieu of conviction, so in a moment you'll be asked to change your plea to guilty to the 2 counts of the indictment. The court will accept your plea but not make a finding of guilt. Instead, I'll hold your plea in abeyance or set it aside and require you to complete a plan of intervention. If you successfully complete that plan of intervention, then the prosecution of this case will end with no finding of guilt, and I'll dismiss these charges against you. Do you understand that?
Yes, sir.
However, if you fail to complete the plan of intervention, if you continue to make the choices that you're currently making, then I will be able to make a finding of guilt that's based on your plea today, and then I'm going to sentence you on these felonies. Do you understand that?
Yes, sir.
How old are you?
I just turned 19 April 2nd.
How far did you go in school?
I made it to a junior in high school.
A junior in high school?
Yeah.
Are you a citizen of the United States?
Yes, sir.
Can you read and write?
Yes, sir.
Are you has anyone promised you how the court would sentence you in this case if you fail to complete ILC?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Ms. Chambers?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
You believe you understand what it says?
Yes, sir.
This document says you're running a plea of guilty to 1 count of grand theft of a motor vehicle as a felony of the 4th degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The second count is one of receiving stolen property, also a felony of the 4th degree. That too carries a maximum penalty of 18 months in prison and maximum fine of $5,000. Neither of them carry mandatory prison sentences. Do you understand the maximum penalties involved?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means if the court sends you to prison on these charges when you are released, the adult parole authority may choose to supervise you for up to 2 years. If you violate those rules of supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison. Even if you fail to complete ILC, the court still has discretion to place you into community control, or what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've gone over?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed today.
Yes, sir.
All right, Ms. Nicholson.
Your Honor, if this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about May 18th, 2025 in Deerfield Township, Warren County, Ohio, police were called out in the early morning hours to a neighborhood in Deerfield Township related to a series of car break-ins. There were black males seen running to the stolen car, which was a BMW, after breaking into the cars on surveillance video. The police officer spotted the BMW. It fled at high rates of speed. Defendant was a passenger in that vehicle. He was the only adult in that vehicle. That BMW was stolen on the same street that the car break-ins had been reported on. The defendant was involved in the theft of and possession of that stolen vehicle.
Ms. Chambers, anything on those facts?
No, Your Honor.
Mr. Veal, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over.
Yes, sir.
What's your plea?
Guilty.
The court will make a finding you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. I am going to grant your motion for intervention in lieu of conviction and order these proceedings stayed pending the completion of the terms of that supervision. So you'll be on ILC for a period of 3 years, subject to the supervision ultimately of the Warren County Probation Department. You are ordered to refrain from use of any drugs, alcohol, or marijuana. Do you understand?
Yes, sir.
What do you want to do with your life?
I'm looking for my first factory job right now. I got a little landscaping stuff under the table, but I really want some more money out of it. So
Well, for a 19-year-old, you got a pretty bad record. When are you going to stop and make better decisions? Have you ever had something stolen from you?
yes,
Not a very good feeling, is it? So why would you do that to someone else? If you don't like someone stealing from you, why would you steal from someone else? Mr. Veal, I'm going to give you this opportunity because I think you can do it, but you're going to have to apply yourself better. You've got to make better choices, okay? So you are ordered to successfully complete mental health and substance use disorder treatment. I've already told you, you're not old enough, well, you are old enough now, I guess, to smoke marijuana, but you're not going to do it. It's going to make things worse for you. So if you smoke marijuana, if you get out and start smoking, I'm going to have you arrested. Are you clear on that?
yes, sir.
All right. I want you to get your GED.
That's cool.
A few moments later.
Indigent for the purposes of retaining counsel, and I will appoint Attorney James Moss to represent you in this matter. The court finds that there is probable cause you have violated the terms of your community control. I'm going to set this matter for final hearing. At this time, I'm going to take you into custody. You're going to start serving your 3 days right now. That's all.